Hi, so I'm here to talk about old school rhetoric, new school cognitive science, and good legal arguments. My thesis is that ancient rhetoric wisdom endures today because it works. And it works because it aligns with what we know about humans, how we process information. So these old ancient traditions of rhetoric, they are curiously aligned with modern cognitive science. So Corax, 466 BC, this is the structure of a good argument. Introduction, facts, the argument, and the conclusion. This basic skeletal structure has remained with us for years. The Roman Empire gave us two new things: the questions presented, or statement of issues, and the outline of the arguments, or the summary of the arguments. If we fast forward to today, modern legal arguments, any brief that you see filed in an appellate court today has this basic structure. The order has changed slightly, but the parts are the same. And this just goes to show that the way we argue as lawyers hasn't changed since 466 BC, basically, and it hasn't changed because it works. The syllogism. The syllogism is how you make a point. The idea is that you distill an argument into 3 lines. Basically, any argument, if you can distill it into 3 lines, that gives it memorability. Socrates, can you fit yourself into a box labeled man? If you can get into that box labeled man, then guess what? You're mortal. Syllogisms rely on transitivity, containers, and categories. It's all about how you fit the information into the boxes to move the argument forward in 3 lines. IRAC. Every law student in the country learns some variation of IRAC. This is how we teach lawyers how to write. What's the issue? What's the rule? How do you apply the rule? What's your conclusion? The core of IRAC is the syllogism. The core of IRAC is this ancient thought structure, this ancient deductive logical thought structure. Contracts. When is a contract enforceable? If it's worth over $500, it has to be in writing. This is basically the syllogism. If your contract to sell your car for $12,000 is not in writing, then it cannot be enforced. The syllogism then becomes IRAC when we add the issue to it. The issue comes from Cicero. What is the issue? Is Stuart's contract to sell his Porsche enforceable? Well, we know it's not enforceable because it's not in writing. And we can organize this into 3 lines plus the issue. Syllogisms come from this idea that it derives from Aristotle, which is that everything can be put in its place. You can name things, put things in categories, and once you do that, then you can make new knowledge with syllogistic reasoning. The syllogism is also very clean. You're either in or you're out. If you're not in that box, then you're out of the equation completely. You win or you lose. You win your case, you lose your case, you have a claim, you don't have a claim. It's very dichotomous. The thing about syllogisms, though, is that judges love them. Judges, when we argue as lawyers, they want to hear logical arguments. They don't want to think that they're deciding cases based on passion, emotion, or their political preferences. So if you can present your argument in a syllogistic form, then you're going to win, or going to be able to win for your client. Is a sandwich a burrito? So this is based on a real case. And again, it all depends on how you structure the first line of the syllogism. Is a sandwich a burrito? Well, maybe, maybe not. It depends on how you define what a sandwich is. If a sandwich requires 2 slices of bread, then no, a burrito is not a sandwich. But if a sandwich is an item of food with filling, meat, whatever, and it's surrounded on or within or on top of a grain-based product, then yes, maybe a sandwich can be a burrito. Cognitive scientists have criticized this way of thinking because it's not really how we think. There are birds, but a robin is more like a bird than the penguin. So this idea that all things can be put in a box and treated equally isn't really how reality works. In addition, syllogistic reasoning can lead to terrible outcomes. Before the abolition of slavery, humans, based on the color of their skin, were categorized as property, not as humans. And this was the use of syllogistic reasoning to perpetuate slavery, a horrendous thing. So why do we continue to use these ancient thought structures? Well, humans love neat information. We love things organized neatly. This is a tumbler, things organized neatly. The human brain craves order and structure, and if we can present complex information neatly, that helps. Number two, the syllogism is a way of distilling complex information down to 3 lines. It's a way of chunking information, much like a phone number. It's much easier to remember 3 digits and 4 digits than it is to remember 7 digits. The syllogism accomplishes the same thing. You're taking a mass of complex information and distilling it into just 3 lines. Finally, fluency. Authors who can write in a fluent, clear fashion are rated more favorably by the reader than authors who are writing in a very complex, hard to understand way. And these ancient rhetorical principles help us accomplish fluency. In conclusion, these ancient rhetorical thought patterns, structures, they're very helpful, but we must take them with a certain level of criticality and understand that they can be used to harm. But ultimately, all lawyers should have this kind of knowledge.